In a dramatic turn, the Supreme Court refused to review challenges against broadened assault weapon prohibitions across 19 states. For owners of 8 specific firearm categories, the clock is ticking. Registration, transfer, or surrender must be completed by July 1st, 2026, or face felony charges. This ruling leaves millions of firearm owners confronting immediate legal consequences. On Monday, the court, in a 7-2 decision, allowed lower court judgments supporting state bans to remain intact. The affected firearms include AR-15 pistols equipped with stabilizing braces, AK-style pistols, AR-10 rifles chambered in, .308 Winchester, semi-automatic shotguns with detachable magazines, 50 BMG semi-automatics, belt-fed semi-automatics, firearms with binary triggers, and guns with forced reset mechanisms. States enforcing these measures span from California, New York, New Jersey, Maryland, Massachusetts, Connecticut, Rhode Island, Hawaii, Illinois, Washington, and Colorado, to New Mexico, Virginia, Delaware, Minnesota, Vermont, Maine, and New Hampshire. Possessing any of these firearms beyond the July 1st deadline could result in up to 10 years of imprisonment. The legislative wave of 2025 and 2026 targeted specific platforms and configurations: AR pistols, high-caliber semi-automatic rifles, semi-auto shotguns with detachable magazines, and certain trigger systems became focal points. Gun rights organizations mounted legal challenges under the precedent set by Bruin, but the lower courts issued mixed rulings, leaving enforcement uneven until now. The Supreme Court's decision, with only Justices Thomas and Alito signaling interest in hearing the case, effectively upholds the bans, making the July 1st deadline enforceable in most states. Now, let's examine the prohibited firearms in detail. First, AR-15 pistols with stabilizing braces, semi-automatic handguns built on the AR platform with braces, now considered stocks by the ATF, are banned regardless of barrel length. States argue that these braced pistols operate effectively as short-barreled rifles, skirting National Firearms Act restrictions. Second, AK-style pistols, semi-automatics modeled on AK-47, AKM, or AK-74 designs, are prohibited regardless of caliber or barrel size. This includes models like the Draco and Mini Draco, with authorities claiming these handguns maintain significant firepower while circumventing rifle regulations. Third on the list are AR-10 and .38 semi-automatic rifles chambered in .308 Winchester, 7, 62 NATO or equivalent high-caliber rounds, as well as larger cartridges such as 300 Win Mag and 6, 5 Creedmoor. Examples include DPMS-R 308 and SCAR 17 rifles. Lawmakers cite their long-range capability and barrier penetration as public safety threats, banning all semi-automatics and calibers over 30 except traditional hunting rounds and bolt-action rifles. Fourth, semi-automatic shotguns capable of accepting detachable magazines are prohibited, including Saiga 12, Veer 12, and UTS 15, with the rationale that detachable magazines enable rapid reloading, heightening their danger. Fifth, 50 BMG semi-automatic rifles such as Barrett M82, M107, BFG 50A, and Armalite AR 50A are banned for their potential anti-material applications beyond civilian use. Sixth, belt-fed semi-automatics, including M249, PKM, and MG42 variants, are forbidden due to their sustained fire capability incompatible with civilian purposes. Seventh, firearms equipped with binary triggers, which fire once on the pull and once on release, like Franklin Armory or Fostech Echo models, are banned, with states asserting these devices circumvent machine gun prohibitions. Finally, guns with forced reset triggers are included in the ban, further tightening restrictions on semi-automatic firearm modifications. Compliance is now urgent. State authorities are moving swiftly to enforce these bans, and penalties for possession after the July 1st deadline are severe. The legal landscape for gun owners in these 19 states has shifted decisively, leaving little room for delay or misunderstanding. Every owner of the listed firearms must act promptly to avoid criminal liability, as the Supreme Court's refusal to hear the case has cemented the enforceability of these sweeping new restrictions. Forced reset trigger firearms, or FRTs, are designed so that the trigger automatically resets after each shot. This category includes models like the rare breed FRT-15. Authorities maintain that FRT mechanisms essentially convert a firearm into a machine gun, prompting outright bans on both the devices themselves and firearms equipped with them. The enforcement landscape varies across 19 states. Tier 1 states have immediate application beginning July 1st, 2026. This group includes California, New York, New Jersey, Connecticut, Maryland, Massachusetts, Rhode Island, Hawaii, and Illinois, all implementing comprehensive bans with hard deadlines. Some, like California, New York, Connecticut, and Maryland, operate registration programs, while New Jersey, Massachusetts, Rhode Island, Hawaii, and Illinois require owners to either transfer their firearms out of state or surrender them entirely. Tier 2 involves phased enforcement stretching from August to September. States like Washington, Colorado, and Virginia have staggered deadlines due to logistical delays. In Washington, registration is required. Colorado and Virginia demand transfer or surrender. Tier 3 covers firearms laws enacted more recently from October through the spring of 2026 in states including New Mexico, Minnesota, Vermont, Maine, and New Hampshire, offering longer windows for compliance. Most of these jurisdictions provide registration options, allowing firearm owners to report each banned weapon to state police, supplying serial numbers, make, model, proof of ownership prior to the ban, and paying fees ranging from $25 to $200 per firearm. Missing the deadline carries criminal liability, and registration does not authorize future in-state transfers, only sales to out-of-state residents or law enforcement. The Supreme Court's denial of certiorari does not equate to a declaration of constitutionality. It simply reflects the court's decision not to hear the case at this time, possibly for procedural reasons, insufficient circuit splits, or because the case is not yet an appropriate vehicle for review. With a 7-2 vote, Justices Roberts, Sotomayor, Kagan, Breyer, Gorsuch, Kavanaugh, and Barrett denied certiorari. Only Justices Thomas and Alito would have granted review. The move surprised some observers who expected traditionally Second Amendment-friendly justices to intervene, fueling speculation that the court is waiting for more complete records or to observe effects on pending litigation. Lower courts had issued split rulings. The Third, Fourth, and Ninth Circuits upheld bans, citing historical analogs found in dangerous and unusual weapons laws, including Heller's references to regulations on Bowie knives and other arms deemed unsuitable for militia use. Conversely, the Second and Fifth Circuits struck down similar prohibitions for lacking historical precedent. The Supreme Court's refusal to resolve these splits leaves the bans enforceable in states within circuits that upheld them. Third Circuit states include New Jersey, Pennsylvania, and Delaware. Fourth Circuit covers Maryland and Virginia. Ninth Circuit includes California, Washington, and Hawaii. In circuits striking down bans, Second Circuit covers New York and Connecticut. Fifth Circuit covers Texas and Louisiana, though Texas enforces bans due to state Supreme Court rulings under its own constitution. The end result is that 19 states are actively enforcing the restrictions. Legal challenges will persist, and future review remains possible in 2027 or 2028, but until the court revisits the matter, deadlines and bans remain fully in effect. Compliance before July 1st is critical. Where registration is offered, California, New York, Connecticut, Maryland, Washington, Colorado, Virginia, New Mexico, Delaware, Minnesota, Vermont, Maine, and New Hampshire, owners must register each firearm by the deadline. The process requires downloading forms from state police websites, providing detailed information about each weapon, proof of prior ownership, and submitting applicable fees. Completion yields a certificate allowing continued possession but does not authorize in-state transfers, sales, or inheritance without compliance. After an owner's death, remaining firearms must either be surrendered or moved out of state. Alternatively, owners may transfer firearms to individuals in states without bans, either by sale or gift. All transfers must go through a federal firearms licensee, and recipients must legally reside in states where ownership is unrestricted, with no intent to bypass the bans. Straw purchases are strictly prohibited, and many FFLs refuse such transfers due to liability concerns, making it essential to secure a willing dealer in advance. Compliance, whether via registration or transfer, is the only way to avoid criminal penalties and ensure lawful ownership under the new state-level prohibitions. For firearm owners facing the bans, losing a weapon permanently is the stark reality if no action is taken. One option is modifying firearms to meet legal requirements. Certain AR pistols can be brought into compliance by removing stabilizing braces, and firearms equipped with binary or forced reset triggers can have those triggers replaced with standard models. Large caliber rifles, however, cannot be altered to a different caliber, and belt-fed semi-automatics remain permanently restricted due to receiver design limitations. Owners must consult state-specific laws to confirm whether modified firearms are eligible for continued possession. Another route is voluntary surrender. Individuals may turn over their firearms to state or local law enforcement before the July 1st, 2026 deadline. Many states provide an amnesty period for weapons surrendered prior to the ban, though no compensation is offered and all firearms are destroyed. A written receipt is issued, allowing owners to avoid criminal prosecution despite losing their weapons. Relocating to a state without restrictions is another, though disruptive, alternative. To legally bring firearms into a free state, owners must establish bona fide residency. Temporary moves solely to evade the law do not qualify. While this approach preserves ownership, it demands uprooting one's life. Attempting to hide firearms is not a viable strategy. Noncompliance after the deadline constitutes a felony, and discovery during routine traffic stops, domestic incidents, search warrants, or red flag petitions can result in 5 to 10 years of imprisonment. The risk is substantial and not worth taking. Penalties after July 1st are severe. Unlawful possession in any of the 19 enforcing states is classified as a felony. First offenses generally carry 3 to 10 years in prison, while repeat violations can escalate to 15 years. And possession during the commission of another crime may result in 10 to 20 years. Fines range from $10,000 to $50,000, and probation is typically not an option for subsequent offenses. Several states impose mandatory minimum sentences, such as 3 years in California and 5 years in New York. A felony conviction triggers permanent forfeiture of firearm rights under federal law, including 18 U.S.C. 922G, prohibiting future possession of firearms or ammunition, even within one's home, and affecting hunting, employment in the firearms industry, and general civil rights. Restoring these rights is exceptionally difficult, often requiring a presidential pardon. Seizure procedures are aggressive. Upon arrest, all firearms, including legally owned weapons, may be confiscated. The burden falls on the owner to prove legal ownership if a firearm is to be returned. Banned firearms are typically destroyed, and even if criminal charges are dismissed, civil asset forfeiture can result in permanent loss. Employment consequences are significant. Felony records impact professional licensing, housing, voting rights, student loans, and future firearm ownership. Many owners affected are active or retired law enforcement, military personnel, or security professionals, leaving them unable to continue careers involving firearms. Discovery occurs through a wide array of channels: traffic stops, vehicle inspections, domestic disputes, home searches, red flag petitions, tips from acquaintances, and other routine or investigative procedures. The paths to detection are numerous and often unavoidable. The Supreme Court's denial of certiorari on Monday leaves lower court rulings intact, solidifying the expanded assault weapons bans across 19 states. The 8 prohibited categories remain: AR-15 pistols with braces, AK-style pistols, AR-10 rifles chambered in, 308 semi-automatic shotguns with detachable magazines, 50 BMG semi-automatics, belt-fed semi-automatics, firearms with binary triggers, and forced reset trigger firearms. Enforcement spans California, New York, New Jersey, Connecticut, Maryland, Massachusetts, Rhode Island, Hawaii, Illinois, Washington, Colorado, Virginia, New Mexico, Delaware, Minnesota, Vermont, Maine, New Hampshire, and other states in their respective circuits. Most states implement a July 1st, 2026 deadline, while some offer staggered compliance in August or October. After these dates, possession constitutes a felony carrying 3 to 10 years in prison, fines from $10,000 to $50,000, and permanent loss of firearm rights. Owners must act decisively. Compliance pathways include registering firearms where available, transferring them to out-of-state buyers, modifying to meet legal standards if possible, surrendering to law enforcement, or relocating to a state without restrictions. Attempting to conceal firearms is not only dangerous, but legally futile. Discovery scenarios are common, and the repercussions of noncompliance are severe and life-altering. The Supreme Court's refusal to hear the challenges cements the current legal landscape. Knowing precisely what you own, where you reside, and the steps required before July 1st is now essential for every firearm owner in these 19 states.